So in the last class we were discussing about prevention of fraud and or improper conduct. So in this case we have seen certain aspects in which there is a chance of creating fraud and what all were the activities. Now we shall study about the case from which we shall get cleared about what all is happening. So Jones versus Lipman 1962, all ER 422. Facts. Seller L agreed to sell his land to J. Thereafter, he changed his mind, and with the objective of avoiding the action for specific performance of the said contract, he formed a company and sold the said land to that company. The newly formed company had only two members, one himself and other was his clerk of his solicitor. Therefore, J filed suit in the court of law against L and his company for the specific performance of the contract. So now what all happened in the case? Firstly, L was a seller who agreed to sell his land to J. Thereafter, he changed his mind with the objective of avoiding action of specific performance of contract. So when L agreed to sell to J, they had a contract which said that L shall sell a land to J. So in order to avoid the action for specific performance of the said contract, he formed a company. So to avoid that, he formed a company and he showed that he sold the land to that company. Now in that newly formed company there were only two members. One was he himself, Mr. L, and second was his clerk. So these two people were there. Thereafter, J, what did J do? J filed a suit in the court of law against L and his company for specific performance of contract. After that, it held the specific performance of a contract cannot be opposed on the ground that land has already been sold to the company, which was created just for such fraudulent purpose. It was ordered that the company should sell or transfer the said land to J. Now, what did the court hold or what did the court say? The court said that the specific performance was seen only to oppose the sale of the land which had already been sold. Means what? That the payment was made, the contract was agreed. So, if it was created for a fraudulent purpose, then it was ordered that company should sell or transfer the said land to J. So, L had to compulsorily sell or transfer the land to J as per the contract. Now, further we shall study about the second case. Formation of subsidiaries to act as an agent merchandise transport limited versus British Transport Commission in 1982 to QB 173. Facts. A transport company wanted to obtain licenses for its vehicles, but it was not possible to get such licenses if the application is given in its own name. Hence, it formed a subsidiary company and tried to obtain licenses by making application in the name of subsidiary. The vehicles were to be transferred to the subsidiary. Now, there was a transport company which wanted to obtain licenses for its vehicles, but it was not possible to get such licenses if the application is given in its own name. Then what did they do? They formed a subsidiary company and tried to obtain licenses by making in name of subsidiary. The vehicles were to be transferred to the subsidiary. Then what did the court hold? The court held that both the companies were treated as one commercial unit and the application for licenses was rejected. Seeing that both the companies were one company, they did not accept the application for licenses and it was rejected. It is clear from the above case that where a company has formed its subsidiary with the basic object of using such subsidiary company as its agent, then in such case, court will not respect the separate entity of the subsidiary and lift the corporate veil to find out the reality of singleness of the two companies. So in that case, what did the company do? Company lifted its corporate veil, and after lifting the corporate veil, it said that the the case of separate entity does not exist, as it was a subsidiary, and it was in reality two companies were one single company. Hence the licenses were not the application for the licenses were not accepted, and in this way they rejected the license for the commercial unit. Now further we have involvement of economic offenses. So what does this say? Whenever a company commits an electronic offense, the company and the directors who are responsible for the violation of such economic laws shall be held liable personally. Now, involvement of economic offenses. Whenever a company commits an economic offense, the company and the directors who are responsible such violation of such economic laws shall be held liable personally. So what, that in case there is some kind of economic offense, so in that case directors who are there and directors who have taken the responsibility shall be held for the violation of the economic laws. Further, we have Sontanu Rai versus Union Bank of India, a case law which has been taken in 1989, 65 Comp Cas 196 Delhi. In this case, the company had violated provisions of central excise law and evaded excise duty. It was held that wherever economic offences are committed by a company, a court has the power to lift veil of incorporation and find out the economic realities. So, in this case, they found that there were violations in the provisions of central excise law and excise duty. Evaded excise duty. So in this case, since the court has the power to lift the corporate veil in case of company and find that what were the economic realities, in this case they found that directors were responsible for evasion of the excise duty, and willful misstatements were to be declared personally guilty. Means what? That the directors who had done this were personally declared guilty. Means every director who had committed or who was there during the time of committing of such fraud, in this case the director shall be personally liable to pay the offences. So what did it say? It was held that wherever economic offences are committed by a company, a court has a power to lift the veil of incorporation and find out the economic realities, and the directors who are involved in such evasion of excise duty by reason of fraud or willful misstatement were to be declared guilty personally. Means what? That the directors were personally responsible. Next is avoidance of welfare legislation. Now what does this mean? If it is found that the sole purpose for the formation of a new company, which is wholly owned by the principal company, was to reduce the gross profit of the principal company, by reducing gross profits, the amount to be paid by way of bonus to the workmen also reduces. The Supreme Court in such case upheld the lifting of corporate veil to look into the real transaction and ultimately held that the amount of dividend received by subsidiary company is required to be taken into account in computing profits of a principal company available for the purpose of giving bonus to the workmen. So what does this mean? That avoidance of welfare legislation. Now what did they, in this case what happened, that a new company was formed which was a wholly owned subsidiary of a principal company, and it was only done for the purpose of reducing the gross profits of the company, because as we know that once gross profit is removed, then we will have the actual profit that a company has created in the year. So if the gross amount is reduced, to reduce the gross amount, what they did was they created a subsidiary company. So in this case company, what did the court do? The court uplifted the corporate veil and checked the real transaction and came to know that the company was the wholly owned subsidiary of a principal company, and it was done solely for the purpose of reducing the gross profit. So the principal company had to give the bonus as per the profit which was decided in the principal company. So the case was Workmen of Associated Rubber Industries Limited versus Associated Rubber Industries Limited 1986. 59 Com CAS 134 SC. Then next we have the case where companies where the company is a sham. The courts have the power to lift the veil where a company is a mere sham or a clock. In Delhi, the Delhi Development Authority versus Skipper Construction Company Private Limited, the Supreme Court held that once it was found that the director and members of his family have created several corporate bodies which were mere cloaks, and the aim of such a formation of corporate bodies was to commit illegal activities and thereby defraud people. In such case, courts are justified in lifting the corporate veil and treating the director and his family members as the owner of all such corporate bodies and treating all such corporate bodies as one entity. So, in this case, what they said was that Delhi Development Authority, this case took place between Delhi Development Authority versus Skipper Construction Company Limited in the year 1966. So, in that case, the Supreme Court found that directors and all the members have created, directors and his family members had created several corporate bodies which were cloaks, means which were fake and which were merely for the illegal activities, to commit illegal activities with the money of company. So in this case, the court had the right of lifting the corporate veil and treating the director as well as his family members as the owner of all such corporate bodies and treating these bodies as one entity. That is, all these people were treated as one person, and they came to know about this after lifting the corporate veil. Then, determination of technical competence of the company. When a particular new company submits a tender for performance of a technical work, it is possible to consider the technical experience of its constituents as the experience of the company. In New Horizon Limited versus Union of India 1 Comp LJ 100 section, the Supreme Court held that in such circumstances, the experience of the constituents shall be considered as experience of the company. So now what does this mean? Determination of technical competence of a company. Means what? That when a company submits a tender for a performance of work, it is considered that technical experience, that is, all the people who are having experience in the company shall be experienced and shall have the knowledge of whatever they have provided in the tender. So, in this case, what happened? Thus, it is clear from the above exceptions that the court have tried to deliver justice by keeping in mind the public interest and public policy without taking any statutory aid to meet the needs. In other words, the court's experts expect that companies should conduct their business honestly. If they don't do that, then the corporate veil can be lifted to identify and punish the persons who misuse the principle of corporate entity. So when the corporate veil of this case was lifted, in this case, then they found that it is important to punish the persons behind this misuse, behind the people who are misusing the principle of corporate entity, because it is very important to know that the public interest or the people in the public are more important for the company to function. Hence, the court, while delivering any kind of justice, shall see to it that public interest or the public confidence is not being harmed by the people. Now, we have seen judicial exceptions. Now, we shall see statutory exceptions. What are the statutory exceptions of the Companies Act? Corporate veil may be lifted under the statutory provisions also. There are many sections of the Companies Act under which the separate legal and separate corporate personality of a company shall be disregarded. These exceptional circumstances are as follows. So what are in the statutory documents, what shall be the exceptions? So first one is misstatements in the prospectus. Now if there are misstatements in the prospectus, there are chances of creating fraud. Means what? Since the prospectus is a compulsory document of the company, so in this case there will be misstatements. If there are misstatements or untrue statements in the prospectus issued by the company, then all those persons such as the director, promoter who have authorized the issue of the prospectus would be liable to pay compensation to every person who subscribes the shares or debentures on the basis of the prospectus. So if there are misstatements in the prospectus, then in that case all the directors, promoters or the person who have authorized to issue the prospectus, all the people shall be responsible and shall be liable to pay compensation to the shareholders or the debenture holders depending upon the basis of prospectus, and for any loss or damage he may have sustained by the reason of such untrue statement. So if the public finds that he has failed, or if they state that the people have faced losses due to this untrue statements in the prospectus, in this case the directors, or in this case the promoters or whoever is responsible shall be liable to pay all the compensation to the person. All such persons are criminally liable for such untrue statements. Punishment provided in the Act is imprisonment for a term not less than 6 months, but which may extend to 10 years, and with a fine which is not less than the amount of loss and which may extend 3 times the amount of loss or damage. So in this case, if there is misstatement in the prospectus, in this case the punishment or the person who is liable shall be imprisonment for not less than 6 months, and which may extend to 10 years depending upon the amount of loss or amount of crime which he has committed, and it shall be criminally liable, and which shall be fined, which shall not be less than the amount of loss to the third party, and which may extend to the 3 times the amount of loss or damage caused to the party under section 447. Now earlier we have seen about section 339, which shall be fraudulent conduct. So what shall be the connection between that statement and this? So it has a fraudulent conduct. Sometimes in the case of winding up of a company, it appears that some business of the company has been carried on with the intent to defraud creditors of the company or any other persons, or with the any fraudulent purpose. Now what does this mean? That sometimes a company company may be winding up, company may go into winding up if it appears that the company was solely created for the purpose of creating a fraud, or for the purpose to defraud the creditors of the company. In that case, the company shall be wound up. In such circumstances, the tribunal may declare that the persons who were knowingly part of carrying on the business in this manner are personally responsible for all the debts or other liabilities of the company, as the tribunal may direct. So in this case, whoever has been fraudulently doing, or whoever the tribunal declares that these people are responsible, then in this case every person who has been declared by the tribunal shall be personally responsible for paying all the debts and other liabilities of the company, and it shall be directed by the tribunal that how it shall be paid, how much it should be paid, and in what circumstances it shall be paid. Further, we shall discuss about holding subsidiary company. From the point of view of law, the holding company and its subsidiary are two separate legal entities. According to section 129, every company lay before annual general meeting financial statements of a company. The holding company shall, in addition to financial statement, prepare a consolidated financial statement of the company and also of its subsidiaries, which shall be laid before the annual general meeting. This is an instance of lifting the corporate veil. So, when a company is a holding or a subsidiary company of another company, so in that case, the principal company shall be liable to file a consolidated, that is to combine all the holding and the subsidiary companies books of accounts, or to combine all the important documents of the company and shall be present, that is all the financial statements shall be provided in the annual general meeting. And this is one of the instance of lifting of corporate veil, which is compulsorily done. Further, we shall see about investigation of ownership of company. When the central government thinks fit, it may appoint one or more inspectors to investigate and report on the membership of any company to determine the identity of the persons who are financially interested in the company and who have real control over the policy of the company. So, investigation of ownership of company. What does this mean? That if a central government thinks fit, it may appoint inspectors either to investigate and take reports of the members of the company. So, like we saw in the Salmon and Salmon case, that the members were of family members only. So the central government has the right to inspect who all are the people of the company and report about the members of the company, so that the company knows, so that the court knows that who are the real people behind the company and what all things are going on in the company, because they know that public interest or the confidence of the public is dependent upon this. Next, we shall study about liability under the Income Tax Act. According to the Income Tax Act, where any private company is wound up, and if tax arrears of the company in respect to income of previous year cannot be recovered, every person who was the director of the company at any time during the relevant previous year is jointly liable for repayment of tax. Now, liable under the Income Tax Act. What does this mean? That liability under a Income Tax Act, what does this state? That according to the Income Tax Act, where any private company, if in case a private company is getting wound up, so in that case what shall be done? The arrears of the company, that is tax arrears, anything related to the tax, shall be remaining for the previous years, and which is not been paid, and which the company is unable to recover. So, in that case, all the directors of the private company who were there during the previous year shall jointly be liable for the payment of tax, because government will not take any losses because of the public. So, in that case, if you are earning profit and if you are winding up your business, in that case, if you have winding up, it is compulsory for you to pay all the taxes for the entire financial year which you are responsible for. So now what is the conclusion? Conclusion is that incorporation does not cut off personal liability at all times and in all circumstances. Honest enterprise by companies is allowed, but the public is protected against kidding and hamburgi, that is fraud. The sanctity of a separate corporate identity is upheld only in so far as the entity is consistent with underlying policies which give it life. So, with the conclusion, we can say that incorporation does not cut off personal liability. So, with this all the points which we studied about corporate veil, we can say that the personal liability, that is, as we studied a point that company has the shareholders of a company have limited liability. They have limited liability, but the personal liability shall be always in consideration whenever we are studying these, because the court or the law shall see to it that the public interest of the company public interest of the people who are there, who are residents in that place, and the shareholders shall be given protection more than the members who are in the company, because company is an artificial person and these people shall commit frauds or shall take away the hard-earned money of the normal individuals. So it is said that corporate will is one of the important concepts, and it has variety and different provisions which shall be used in different cases. So, hence we can say that if public interest or public policy is at stake and someone is misusing the principle of separate entity of a company, it becomes necessary to lift the corporate veil either by judicial intervention or statutory provisions. So, we have studied the judicial intervention and statutory provisions. So, I hope you have understood till here. Now in the next class we shall start with various types of companies and we shall study about them in detail. So we shall stop here. Thank you.